Okay, here we go. Can everyone hear me? Yes? Okay, good show. All right, so I presume everyone in the audience can hear me, and you can see the pictures and the videos of everyone. Diane, where are you? I don't see Diane. I'd like to welcome everybody. We have 505 people registered, and I would expect, based on past history, fewer than half of those to attend, but that's not a bad number. The 500 is an average sort of number for us. Between 400 and 600 is pretty average. And I see we're starting to already get questions. I think everyone that's taking part understands the nature of our firm and what we do. And I see as we proceed with these, I always see a lot of familiar names, which is great, right? We, last I checked, we had 170 questions submitted at the time of registration. I'm sure we have more than that now. Plus we have the questions that are submitted online here, as you can see, or as we can see. I'd like to just make one simple announcement, and then I'll turn the process over to Christiane Marchand, and she'll be directing the questions, and people will be answering. As they answer, their their video will show for you, and the others of us will do our best to continue to answer the questions that come in. We've tried, you can understand that a lot of the questions are similar or follow certain themes, and each of us has areas that we practice in more than other areas, although we all handle pretty well everything. But there's at least two people that of each specific practice area that focuses on any given thing, such as Henson Trusts or tax credits or benefit increases or these sorts of things. So I think we're all ready to go. The last comment is that we're just now activating and rolling out a podcast channel. You can go to our website and listen to podcasts or audios of past videos. Christiane will be sending the notice out to everybody next day or so, I would think. And yes, this video and the PowerPoint slides and so on will be sent out to everyone who registered. So the 505 people will get it, and we now have 196, 97, and so on taking part. People will continue to register until approximately five after. That's pretty standard. So when we get to the high point, the high water mark, I'll let you know what that is. If you don't get questions answered, you're welcome to either fill out the family evaluation form on the website, or to send a contact link, or to download the e-books for Henson Trusts or Guardianship on those landing pages, and you'll be invited to send more information about your situation, your family situation, and we'll do a complimentary assessment of what we think could be done to make your life a little better. And if it's appropriate, then we have a short courtesy consult to discuss some of those details and see if you would like assistance. So that being said, I'd like to turn the mic over to Christiane, and Christiane will proceed from here. We'll do our best to answer the questions we can in the next 55 minutes. We might run a little bit over. We'll see if, when people start to leave. There's 215 right now. So Christiane, take it away.
Sure, thanks, Ken. We'll start with a question from Heather. She's asking, does my son need 2 separate bank accounts for his ODSP and money from a Henson Trust? Crystal, do you want to take that one?
Sure, I can. Sorry, I'm just looking for my answer here. So, no, you do not need 2 separate bank accounts for a Henson Trust. In general, payments are made directly to the person's general everyday bank account. This is because ODSP usually likes to see how much money they're receiving as disbursements from their Henson Trust. Another way you can also distribute money from a Henson Trust would be directly to third parties. So sometimes we have situations where landlords need to be paid or bill companies need to be paid. And it's often the case that instead of putting the money through the beneficiary of the Henson Trust's hands, a lot of the times a trustee will pay these third parties directly to avoid the money going through the person's bank account. So if the money is going to be used by the person, then yeah, you can put it right into their bank account. There's no need for a second bank account.
Next question is from Bev. She's asking, how can you find out if someone has applied or been approved for the disability tax credit? I can take that one. There's a couple of ways. You can either just call CRA and ask them. The number for that is 1-800-959-8281, and be prepared to answer some security questions like date of birth, SIN number, and information on the most recent tax return. Another way to go about it is to apply for the CRA online account. You just have to fill out some basic personal information, and then they mail you a security code. And once you get that entered, then you have access to this online portal that you can see all of your tax slips and tax returns, and also disability status and any other kind of benefits like HST, Trillium, etc. So I think that would be the better way to do it, because there's just so much more benefit along with that route. But like I said, you could just give CRA a call and they can tell you over the phone and mail you the eligibility letter if there is one on file. Next question. This is from Suzanne. She wants to know, should I go through the guardianship process now with someone that I appoint for my son rather than wait till I'm older and possibly too late kind of thing? Diane, I'll give you that question.
Thanks, Suzanne. We get this question a lot. There is no right answer. So let me just touch upon wills for a bit. Many people like to include in their will, if they have one, a paragraph about their wish or wishes on who they want to become the legal guardian of their child in the event that they do pass away. These paragraphs are not legally binding, so it's not a legally binding guardianship appointment. They're only persuasive. And so this means you cannot automatically be appointed as a guardian simply by being named in a will. Instead, that person who was named in the will would have to apply in court to become the guardian. So just some considerations for you. If you do want to apply now with the person whom you want to become the legal guardian, you should take into consideration that if there is more than one applicant, they are going to be appointed jointly. In a guardianship application, you can't appoint a substitute guardian, so they're appointed jointly. So take it into consideration, is this a person that you can work with together in making decisions together for your son? Also consider whether the cost of the guardianship application is something you want to pay now, or would you rather have it paid by that person you're thinking of, or would you rather have it paid from your estate when you're gone? Thanks.
Diane. The next question is from Jessica. She's asking, or rather stating, I will be creating a will for the first time and would like some guidance on where to start. Jennifer, that's a good question for you.
Hello, hi Jessica. Thank you for your question. Yes, creating a will for the first time can be a daunting task. However, granted that you would understand that you are leaving your property to somebody, and property just means like in essence your stuff. You're leaving your stuff to someone that when you pass away. Now, what happens usually is that we have an appointment, we sit down together, I go through a will questionnaire with you, we draft the document, we go over the document, we also make any changes to this said document, and all the while realizing, you know, we are realizing that yes, your property is going to somebody, the ramifications of that property going to somebody, and any ramifications if you choose to leave somebody out of your will. Now, without going into any specifics, we would have to sit down and have a conversation on what your wishes are, what your estate plan needs to be, wants to be, and then how we can do that for you. So.
Thanks, Jennifer.
Thanks.
Next question is from Grace. She's asking, can income property be held in a Henson Trust? And if so, what are the tax implications? Rafiga?
Hi everyone. Thank you, Grace, for your question, and Christian. Well, a short answer is yes. However, there may be a disposition at the time it was transferred, which can trigger capital gains tax. If it's a testamentary trust and the beneficiary lives in a house that was transferred to the trust, it can qualify for a principal residence exemption. It used to be that this exemption was allowed for inter vivos trusts, meaning trusts that were created during the lifetime of the person who created it, of a settlor. However, in 2016, rules changed. For now, I can say that for a testamentary trust, a principal residence exemption is allowed. Hopefully this will change in the future with regards to lack of this exemption for inter vivos trusts. We'll continue monitoring for any possible changes, but for now, yes, that's the answer.
Thanks, Rafiga. Next question is from Rachel. In regards to the caregiver tax credit, if there's an elderly parent living on their own, but their son is caring for them, can the son apply for the credit? It depends. If they are relying on the son regularly and consistently for the basic necessities of life, mostly food, clothing, and shelter is what CRA looks at. You know, maybe the elderly person has mobility issues and they need help to get their groceries every week, you know, that counts. You'll also want to have some sort of medical document on file stating, you know, the impairment that the elderly person is experiencing. Like I said, whether mobility issues or any other need for that extra support. And otherwise, yes, they could claim the credit. They don't need to live together as used to be the rule until 2017. Next question is from Dean. He's saying he wants a better understanding of the Henson Trust Fund and the assets our son is allowed to hold. Crystal?
So a Henson Trust is a testamentary tool that's used to protect a loved one's inheritance. The main reason for a Henson Trust is to protect against your disabled loved one's benefits from losing their benefits. And then a secondary reason is to protect the inheritance from divorce or from bankruptcy. The trust provision in the last will and testament is to have very specific wording. And our office is able to review your will for a small fee just to make sure that those specific wording is in there and advise you accordingly on whether or not your Henson Trust is a proper, true Henson Trust or not. And there is no limit to the amount that a Henson Trust is able to hold. ODSP would lead you to believe that only $10,000 per year can be withdrawn from the trust without affecting benefits. This isn't really the case. We are able to assist the trustee to disperse the desired amounts or the needed amounts, and it does have a very minimal effect on benefits, but but they're really, you don't have to stick to the 10,000 rule like ODSP would lead you to believe.
Thanks, Crystal. Next question is from Wes. He says, our son turns 17 next month. We've been told different things about how and when is the best time to apply for ODSP. Looking for advice. Diane?
Hi, Wes. Thanks for your question. I would start looking into ODSP as soon as possible. Some of our clients start looking into applying for ODSP probably about 6 months before their child's 18th birthday. And we certainly can assist with this process to make sure it's a smooth transition from when they're 17 and they turn 18. We also try our best to make sure that the application is not denied the first time around. So there are various forms to fill out, and it's important that when the application is made, that it's done as properly as it can be, and that important information is not left out, because we want the application to succeed. It's also important to consider that the application process can take anywhere from 3 to 6 months. The medical part of the application is reviewed by the Disability Adjudication Unit, and they can take up to 90 days to make a decision. Now, if your child already qualifies for services under DSO, which is the Developmental Services Ontario organization, they would already medically qualify for ODSP, which makes the application process faster. Thanks.
Thanks, Diane. Next question is from Louise. She says, my sister would like to leave an inheritance to our disabled son. How should she do this? Jennifer?
Hi, Louise. Thank you for your question. It's a very good one, and it's a common one that we do get quite a bit. Now, presumably, you have already incorporated a Henson Trust provision into your will. And so what would happen with your sister's will, she would leave a specific wording saying to the fact that I leave X amount of dollars or a gift to the Henson Trust of my son, which you put your son's name. She would basically have, in essence, she would leave the gift into your son's Henson Trust, so that, presumably to protect from ODSP clawback and such not. Thank you.
Thanks, Jennifer. Next question is from Aisha. She's asking, does the 21-year disposition rule apply to the Henson Trust? If yes, then what happens after 21 years? Rafika?
Yes, so hi Isha, thank you for your question. This is a common question actually. Lots of people mistakenly think that trusts have a 21-year lifespan. The 21-year rule deems certain types of trusts to dispose of their capital property and recognize capital gain taxes every 21 years. So to give you an example, imagine that you bought a rental property and transferred it in trust for your son. So at the time of this transfer, your son is 7 years old. The value of this property at the time of purchase was $200,000, which is also called an old adjusted cost base. So 21 years pass and your son is now 28 years of age. The capital gain tax has to be paid, and it should be about $50,000 if the value of the property is now $400,000. So $50,000 is a lot of money. Where do you get the money to pay the tax? You'll probably have to mortgage the property. However, you can attribute income to the beneficiary, which can reduce taxes to the same extent. So now that he is 28, you can roll out assets at the old adjusted cost base, which was $200,000. And then one day when he dies, there will be a deemed disposition, which will trigger capital gain tax. So basically, that's a short answer. Thank you.
Thanks, Rafika. Next question is from Gustav. He's asking, can a person with a disability have a Tfsa account? Crystal?
So yes, a person with a disability can certainly have a TFSA account. The TFSA normally would fall into the 40,000 personal ODSP asset test. However, there are certain ways that we can increase that 40,000 amount to 100,000 on a case-by-case basis. So the short answer is yes, you can have a TFSA and be on ODSP.
Okay, cool. Next question is coming from Frank. He says, my son is 19 and lives with autism ADD. I wanted to arrange for guardianship and wanted to know the cost and process. Diane?
Hi, Frank. Thank you for your question. So the way that we do guardianship here is through a process called summary disposition. And now what that means, it's a hearing in writing for a party under disability. So there is no in-person attendance needed. Essentially, at the end of the day, the application is about 120 to 200 pages. It's bound, and one copy of this book, this application record, is given to the court. One is given to your son, one is given to each applicant, and one is also given to the Office of the Public Guardian and Trustee, and they review every single guardianship application. If you want to talk about costs, this requires a further discussion, so please contact me and we can talk about that further. If we can, we try to minimize the costs, but essentially what you're looking at are legal costs, costs to the Public Guardian and Trustee, court costs for the application fee, and costs for the capacity assessors. So each guardianship application has evidence as to the allegedly incapable person's capacity, as to their personal care and as to their property. And we use 2 capacity assessments for each, the personal care part and for the property part. When the guardianship application is submitted, the Public Guardian Trustee reviews it. If they have questions, they write to us. Usually their questions are towards, finances, just to make sure that there's no financial abuse going on with the person who's allegedly incapable. The court, if they have questions, his or her honor will also write to us as well if they have any questions. Usually it's the Public Guardian Trustee that has a majority of the questions. We answer it in writing, and if there are no more questions, the guardianship is granted. And then nowadays we receive the judgment electronically, and then we give you notarial copies of the judgment. Thanks.
Thanks, Dan. The next question is coming from Diane. Do we need POA for our disabled son? And should he have a will? Jennifer?
Well, depending on the competency of your son, he can have, we can do POA, powers of attorney, which would allow you to manage his property and manage his personal care in the event of incapacitation. Now, we have to look at whether to see if your son is capable of understanding that the power of attorney for personal care, power of attorney for property, like asking some basic questions about who do you want to take care of you in the event of being ill, who do you want to take care of your finances in the event of you being ill or incapacitated. And now in terms of a will, it depends if he has any substantial property of his own, including an a registered disability savings plan, an RDSP. If he has one of those, then definitely it would be good to have him to have a will. And also if he had any specific requests that he wanted to have certain people make, any of, if he had, say for example, he had a hat collection that he wanted to leave to his brother, and if he wanted to have a pin collection leaving to his sister, then yes, he would probably want to put that into a will as well. Thank you.
Thanks, Jen. Next question is from Lorraine. She's asking, does the person with disability need a will? It's kind of the same question. Who signs it? Yeah, who would sign it? Rafiga?
Yeah, so Jennifer answered a lot of important points already, so I'll just elaborate a little bit. You just need to consider whether it's a good idea to have a will in the first place. In the scenario that Jennifer kindly provided, it's appropriate. But if you think that your adult child can be easily taken advantage of, manipulated, and after both parents are gone, leave his or her inheritance to a random person, maybe it's not a good idea to have a will. Again, going back to Jennifer's example, RDSP, right? So assume that the child died, the adult child died intestate, and RDSP is the only asset that that person had. Well, in the event that there are parents who survived him or her, and there were no spouse, no children, well, in the event of intestacy, parents are the first in line to inherit, well, to get it back, to get the RDSP funds back, including growth, vested grants, bonds, they get it back. So in this scenario where you think that, your adult child, it may be not a good idea to have a will prepared for this person, then consider a scenario where there's an intestacy, and if you're the only one in line to survive, well, you'll get it back anyways. I'll give you an example. We had a client some time ago. So this woman, she had Rett syndrome, RETT. Well, she unfortunately passed away when she was 35. Well, her RDSP went back to her parents. She didn't have a will. So this is just one example. So in both cases, what Jennifer said is true, and in my example, it can also be true. So you just have to consider, is the person capable? Yes. Okay, he or she can sign a will. Well, if capable, is it a good idea to have this will signed in the first place or not? If yes, then yeah, why not? But if no, you have to weigh these factors.
Thanks, Rafiga. Next question is coming from Sandra. She's asking, can someone who's been denied the DTC previously reapply with a new family doctor? For sure, yes. I wouldn't even bother trying to apply with a doctor that doesn't seem supportive and willing to be thorough with the process. But if you, happen to have a new family doctor, or even, there's several kind of specialists indicated on the application itself. So if it's like a mental impairment, you can have a psychiatrist complete the form. If it's physical, sometimes a chiropractor. It depends on what section you're filling out, but absolutely you can have a different doctor complete the form. Next question is coming from Ed. He's asking, can we obtain ODSP for a 28-year-old diagnosed at 12 with Asperger's, or is a new assessment required? Crystal?
So I would request a copy of the reports or medical records from the Royal Ottawa, the ROH, and then make sure that the patient's general practitioner or family doctor has a copy of those reports and assessments. Maybe it's a discharge report or a psychological assessment. Make sure that the family doctor has those, and make sure that the assessment, the past assessment, speaks to current restrictions and limitations. If the family doctor recommends that maybe a new one should be done, then I would follow the recommendations of your doctor. I said, but if the limitations and restrictions are the same, and the situation hasn't changed substantially, then I would say no, a new assessment would not be needed, and the doctor can go ahead and fill out the ODSP medical papers without the need of a new assessment. And all of this can be submitted to the Disability Adjudication Unit, and you can just attach any records or assessments or reports that you think would help support the application.
Next question's coming from Barbara. She's asking, is POA applicable to the person with disability? Is POA applicable to the person with disability or guardianship as person can't make her own plans? Diane?
Hi, Barbara. Thanks for your question. So both a power of attorney document and a guardianship appointment are applicable to persons with disabilities. If this person is able to sign a power of attorney, then generally speaking, they would not have to go through a guardianship application. We only suggest going through a guardianship application if this power of attorney route is not possible. Now, I'm only speaking generally. There are instances where even though a person is able to comprehend and sign a power of attorney document, it is clear that guardianship should still be pursued. So one example is if someone is able to sign a power of attorney, it just so happens that they like to sign every single power of attorney that's put in front of them, then this person might need guardianship, because even though they can understand this document, they're a little bit too trusting for their own good. Thanks.
Thanks, Diane. The next question's coming from Elaine. She's asking, can you explain annuities and if they are helpful for people with disabilities? Jennifer?
Hi, Elaine. Thank you for the question. One of the tools that we use frequently is the use of annuities. They are an investment tool that provides a guarantee. It's like you purchase an annuity with a specific sum, and that guarantees income for like 20 or 25 years. So it's good for persons with disabilities in the sense that, especially if they have no concept of money, they have no concept of spending, that they get a certain amount every month. A certain amount will also, depending on the amount, will also minimize any impact from ODSP clawback. And also we use it as a certain tool for lifetime benefit trust wills, that an annuity is paid out to the child either monthly or yearly, and the tool is used to prevent any clawback. And I understand that if my coworker Crystal can ring in, she would definitely provide a better answer than I have, if I've covered everything on concerning annuities. Thanks.
Thanks, Jennifer.
I just wanted to say the annuities can also be lifetime annuities. They don't generally have to be 25 or 30 years. It's a time period that you pick depending on how much you have to spend and what the life expectancy of the beneficiary is. And another thing that should be mentioned is the payments from the annuity fall into the $10,000 allowable amount from any source for any reason rule at ODSP. So just a couple other things to add to that answer.
Yeah, good call. Next question is coming from Charlene. She wants to know, how do you go about setting up a Henson Trust? Rafika?
Yes, Charlene, thank you for your question. Before answering your question, I just realized that I didn't answer the second part of the question. Lorraine, was it right? So who can sign a will? Just a quick answer. The short answer is, legal guardian or a power of attorney cannot sign a will on behalf of the disabled person. So just to clarify and just to give that answer to Lorraine. Now going back to Charlene's question. Okay, so thank you again for your question. So how do you go about setting up a Henson Trust? Normally, it is set up in a will. Nothing happens until the last surviving parent dies. If the question refers to how to include Henson Trust clauses in a will, that's a broader discussion, but main elements that you need to consider when you're drafting a Henson Trust will is, the point that assets don't vest with the beneficiary, a non-vesting clause, a beneficiary who would normally simply receive payments and distributions, right? The trustee normally, in a Henson Trust clause, the provision dealing with trustee discretion, trustee is supposed to have an absolute discretion, unfettered discretion. Trustee is not required to pay out to the beneficiary upon demand, but may certainly do so if he or she thinks that's appropriate in the best interest of the beneficiary. The trust is thus beyond the reach of the beneficiary. So if this question refers to how do you set up an actual trust account, Henson Trust account, that's again a broad discussion, but to give you useful tools that you need to consider and use when you're setting it up is there are a number of factors. We have a retainer agreement where we list most of these factors, and we do this work on behalf of our clients. So some of these factors are, you obviously, first of all, need to review the testamentary or trust documents. You need to communicate with banks, investment officers to make sure that trust and investment or investment accounts are set up correctly. You consider what can be placed into the Henson Trust. You want to understand, as a trustee, you want to understand different strategies for short-term, medium-term, long-term planning. We have a very useful, what I think is a very useful, and a lot of clients confirmed a very useful list listing Prudent investment trustee guidelines. So it's sort of a list of things that you need to consider as a trustee, and it guides you through this process. If the beneficiary receives Ontario disability support benefits, you want to consider how to handle that aspect, which is a different discussion. But obviously, you also want to think about and plan for tax filings, payments out of the trust account to the beneficiary in a way that it won't affect ODSP payments. You want to think about paid versus payable rule, preferred beneficiary elections. When the time comes, converting Henson Trust into a qualified disability trust. You want to consider also and plan for what happens after the beneficiary passes away. So those are some of the tools that are useful to keeping your sort of toolbox when you're going ahead with this process. But if you have further questions, feel free to contact us and we'll be happy to answer your questions. Thank you.
Thanks, Rafika. Next question is coming from Nell. Are we eligible for the disability tax credit even though our son is in a group home? Yeah, it depends. To use somebody else's credit is on the basis of providing basic necessities like food, clothing, and shelter. So if you are financing some of the shelter costs of the group home, that qualifies. If you're helping out with the groceries or buying them seasonal clothing, that all fits the bill of providing basic necessities. So in those cases, the disability tax credit would be transferable to you. Next question is from Charlene. She's asking, how do I start an RDSP for my disabled child? Crystal?
Sorry about that. So how do you start your an RDSP? Well, firstly, you need to be approved for the disability tax credit. That's a whole process in itself. But once approved, then you should find a financial institution or advisor that you trust. And we always recommend using a financial advisor versus a bank just for the reason that they pay more attention to your investments inside the registered disability savings plan. And we like to recommend people from Edward Jones or Investors Group, just as an example. There's many more out there. Then you should find out and know what kind of grants and bonds you're eligible for retroactively and how you can capture those amounts retroactively. This is done on a case-by-case basis because it really depends on how far back your disability tax credit has been approved for, how old you are, and how many years you can go back retroactively would be based on those factors. The government will contribute a maximum of $90,000 in grants and bonds over a 20-year period. So it's spread out to a maximum of 20 years. And these grants and bonds are payable into your registered disability savings plan till the age of 49. However, we use this as another tool for the ODSP asset test because contributions can be made to a registered disability savings plan until actually the age of 59. It's just that there are no more grants and bonds paid into it after the age of 49. And then from there, you also need to think about a vesting period. So your RDSP needs to vest, is what they say about it, for 10 years from the date that the last grant and bond is put into it. So there's lots of factors that go into it, and that's why we always recommend that you contact a professional to get some advice, just so that you know that you're getting the most out of it.
Thanks, Crystal. The next question is coming from Mamoon. They're asking, can a 65-year-old choose to stay on ODSP versus OAS and GIS if the ODSP is giving more money than OAS and GIS would? Diane, can you take that one?
Yes, thank you for your question. So generally speaking, for a single person who's aging out of ODSP, old age security, so OAS, and guaranteed income supplement, GIS, provide more funds yearly than ODSP does. So ODSP on a yearly basis is approximately $14,000. OAS with GIS is about $18,000 per year, so it's more. But if you're not single, for example, if you were married and you have a spouse who is under 65 still receiving ODSP, then certainly you receiving GIS and OAS will offset her ODSP. This is a hot topic right now. If you're on ODSP, you are supposed to seek out other sources. You're obliged to apply for OAS and GIS. We're now seeing, or we have seen, ODSP sending out letters a year in advance to people on ODSP asking them to apply. I don't know if you can delay your application or what the outcome of that would be if you decided to do that, but I do know that ODSP is a lot more pushy with that. So it remains to be seen, but it is a very hot topic question right now. Thanks.
Thanks, Diane. Our next question is coming from David. He's asking, what happens to the RDSP if the beneficiary dies before withdrawing the money? Jennifer, can you take that?
Thank you for your question, David. As Crystal said, the vesting period being 10 years, grants and contributions stop at 49. However, if the disabled child has passed away before the vesting period is ended or before any payments is made, basically the contributions that the original policy holder has made will be returned to them, minus any grants and bonds that have not been invested. Now, that being said, what happens if the parents had passed away prior to the child, then what happens is that we go, if the disabled child didn't leave a will, to have the residue of his or her RDSP gifted to siblings or cousins or back to the parents, then it goes by succession law. So if the parents have predeceased, then they look at any surviving brothers and sisters, surviving nieces and nephews, and so on and so forth. But in essence, the original contributions are returned to the original policyholder of the RDSP. Thank you.
Thanks, Jennifer. Next question is coming from Catherine. She wants to know, if I turn 65 by the time my parents' estate is settled and I'm no longer on ODSP, can the Henson Trust be dissolved? And if so, how? Rafika?
Yes, so Catherine, thank you, Catherine, for your question. There are a few factors here that play a role. First is the ODSP protection, right? Protecting your benefits. Yes, after 65, the person is no longer on ODSP, and there is no need for the Henson Trust. If that was the initial concern of the parents who set it up. However, there can be more to it. So the second factor is, do you want to give the money directly into the beneficiary's hands? If there is no concern that the beneficiary will spend it in one shot, then this approach may be appropriate and the trust can be collapsed. There are also other advantages, though, in having a Henson Trust set up. So for example, it protects against matrimonial claims if the beneficiary is easily manipulated and can be taken advantage of, protects against those situations, bankruptcy claims. Another benefit of the Henson Trust is that after the beneficiary is 65 years of age, the trust can be, again, as I discussed previously, converted into a qualified disability trust, which will give tax-saving, tax-reducing advantages. So when your adult child turns 65, for example, he or she loses ODSP, as previously stated. Instead, they start receiving the old age security and guaranteed income supplements, as my colleague Diane correctly pointed out. So the total amount of those two should be around $18,000, which is good. It's better than $14,000 from ODSP a year. But if the child also, or the adult child, also received income from the Henson Trust, then for every dollar of income, he loses 50 cents of GIS, guaranteed income supplements. But if you elect a qualified disability trust, then the trust pays 22% in taxes, which is less than 50%. So, thank you.
Thanks, Rafika. The next question's coming from Peggy. She says, I'm told the disability tax credit wouldn't make any difference to my income tax return because my income is so low. That's probably true. The tax credit works against taxes paid. So if you, for example, earned $40,000 in income and then you owed the government $4,000 in tax returns, then the disability tax credit helps reduce that amount. But if you're, for example, on ODSP and you don't have any taxes payable, then using the credit, I mean, there's no taxes payable to apply it to. So it's not a credit like the HST where you'll get a check no matter what. It's to reduce taxes owing. So if you don't have any taxes owing, maybe there's somebody in your life that is helping to support you that could take advantage of this credit instead. Otherwise, if you're under 49, there is still a benefit to using the disability tax credit. So it allows you to open up an RDSP account, which accumulates grants and bonds, which is, beneficial. It's free money. Next question is coming from Nick. She wants to know, if you're on ODSP, how much money can you keep in your bank account at one time? Crystal?
So the answer to that is in 2017, ODSP increased the personal amount to 40,000, and it was raised from 5,000. So many people aren't aware of that. So we like to repeat ourselves over and over that the new asset test is 40,000 and not 5,000. And further to that, you can hold assets, which we can exempt for you, a further 100,000. This money doesn't necessarily need to come from an inheritance. We've got situations where somebody won the lottery, or somebody wants to disperse their estate prior to their death, or it's gifted to them. So if that happens to you and you're lucky enough to receive more than $40,000 at any given time, then you're able to keep that money in an exempt form, also in your name, and it can be up to 100,000. So you can actually have $140,000 worth of assets in your name, accessible to you, used by you at any given time.
Thanks, Crystal. This next question comes from Yin. He's asking, how can a person change or end the powers of attorney? Diane?
Hi, Ian. Thanks for your question. We get that question a lot. So there are multiple ways this power of attorney can end. One is the person who signed the document if they pass away. And another one is, maybe the attorneys who were appointed, they resign as attorney. And usually that's in writing. And that mechanism of termination would be within, the process of it would be written in that specific power of attorney document. Thanks.
Thanks, Diane. Next question comes from Gretchen. She's asking, if a person loses the disability tax credit eligibility shortly before turning 49, can they avoid having the sum returned to them all at once, as well as avoiding losing grants and bonds? Jennifer?
Sorry about that. Basically, as of 2020, the RDSP account is no longer, no need to know, excuse me, pardon. Okay, as of 2020, the RDSP account no longer needs to be closed. It also no longer needs to, you still have to have the, I do believe you have to have the DTC credit to keep the RDSP open. However, my coworker Crystal is definitely more savvy about RDSPs than in our entire office. If she'd like to actually expand upon my question.
So the question is whether or not grants or bonds need to be returned. No, nowadays grants and bonds are not returned. It's held open and paid out normally, even if the disability tax credit expired. In the past, what we would do as a solution is to write to the financial institution and request that the plan stay open pending approval. So that can still be the case, and I would still notify your financial institution that you plan to reapply for the disability tax credit, because there are other advantages to keeping your disability tax credit renewed every time that it expires, because that happens a lot. And so there's tax advantages, and there's advantages if you happen to have a testamentary trust, because then you're qualified, the trust becomes a qualified disability trust. So there are other reasons to keep your disability tax credit going other than the RDSP. But in the event that it is closed right before your 49th birthday, you technically don't have to do anything if you don't plan on reapplying, but we don't recommend that. We recommend that you still notify your financial institution that you're in the process of reapplying, and that you'll notify them when the approval comes through.
Thanks, guys. Next question is coming from Sarah. She wants to know, how much does it cost to set up a Henson Trust for my daughter, And can the lawyer be a trustee if we have no family to choose from? Rafika?
Yes, so the answer is a few $1,000s, not hundreds of thousands of dollars, which is good. And yes, a lawyer can be a trustee. There are trustee fees between 1% to 1.5% a year. So, but a lawyer, yes, can be a trustee.
Thanks, Rafika. I guess it's 5-1, but we still have over 240 signed in, so we'll do a few more. This one's coming from Maria. She wants to know, can the ASD person stop attempts of guardianship? Diane?
Hi, Maria. Thanks for your question. How I interpret that question is whether they can refuse the guardianship. Yes, they can. I'll talk about some of the ways. One is they have to first consent to the capacity assessment from a capacity assessor. Now, I'm not a capacity assessor. Capacity assessors deal with various types of people who they've interviewed, and how they determine what is consent and what is not consent is a question that is more appropriately geared for their answer. So if you want to talk about that further, we schedule an appointment, and then I can discuss that further with a capacity assessor. The other way is that they can actually refuse a guardianship application and contest it. They are supposed to get a copy of the guardianship application. Their immediate family is also supposed to get a copy of the guardianship application. And, like every other application that is put forth to a court, there's always the opportunity to contest it. This would mean bringing their own application, paying for legal costs, putting forth reasons why they don't lack capacity, or why the person who's applying is not the best person to apply. Maybe there's someone else. So those are the two things I can think of right now. Thanks.
Thanks, Diane. This one's coming from Barbara. She's asking, is there an executor if the person doesn't have a will? And what causes a need for probate? Rafika, can you take those?
Yes, sure. Hi, Barbara. Thank you for your questions. When a person dies intestate, the administration of the estate is carried out by the person or persons appointed by the Ontario Superior Court of Justice. The way it's done is by issuing a certificate of appointment of a state trustee. In the case of intestacy, certificate is of a state trustee without a will, which is conclusive evidence that the person to whom the certificate was granted has a right to it. There is an order of preference of the persons entitled to apply for a certificate of appointment without a will. First is a spouse, then children of the deceased, then grandchildren. If none available or predeceased, then parents, siblings, grandparents, uncles, aunts, nephews, nieces. If no next of kin, then it's the public guardian and trustee. Now, going to your second question, what causes need for probate? With a few exceptions, including if there's real estate, you need probate, which proves that this is the last will and you are the executor. Also, often you need to probate to get access to things of value that would not have been otherwise available to you without being appointed an executor of someone's estate. So I hope I answered your question, but if you have any further questions, I'm happy to answer them further. We can have a phone call. Thank you.
Thank you, Rafika. Well, it's just about 1 o'clock, so I'm going to bring this back to Ken. And Ken, do you want to say a few words before we close up?
Yeah, I'll just say a few things. We had a lot of fun today. As I mentioned, we had 170 questions going in, and we've answered a lot by typing responses to the ones that were entered today. Some of them, it's clear that it may be easy to ask the question, but the answer is complicated. If anyone feels they need a proper consult, they should contact Karen, and she'll determine, what's the best step here. This is Karen here. She had a little trouble logging in today, so you didn't see her smiling face, but we'll have to sort that out. So she would intake any questions you have and direct them to the right spot. Some of them are, more substantial. That would be like a proper paid consult. Others might be a short answer. Other than that, we'll be doing these Q&As regularly. We're doing the best we can to answer questions, but of course there's no end to the questions. You can also see that there's some materials on our website, lots of videos, podcasts, and this evaluation form basically tells us who's asking and where they are, and some of the details about the child, because a lot of the questions can't really properly be answered without the context of the family situation. That said, I hope everyone had a good time, and I know that a lot of people got their questions answered. You'll be receiving notice again when we do the next one. We had 260 people registered, which is higher than more than half. Attending, 260 attending, which is more than half of the registrations, which is higher than usual, slightly. So I guess lunch webcasts are good. That said, thank you everyone for taking part. Thank you to all the people that helped to answer the questions, and have a good day.
Thanks, guys.
Thank you.
Thank you. Thanks.
Thank you.
Thank you.